Two of the most important constitutional protections for suspects are the Fourth Amendment prohibition against unreasonable searches and seizures and the Fifth Amendment requirement of Miranda warnings. When police officers have obtained evidence in violation of the Fourth Amendment, courts generally will suppress all evidence derived directly or indirectly from the violation. But what about the consequences of a Miranda violation? Does a similar broad rule of suppression apply? The United States Supreme Court addressed this issue in Oregon v. Elstad. Officers obtained an arrest warrant for 18-year-old Michael Elstad after determining that he had been involved in a burglary. The officers went to Elstad's home, where they ordered him out of his bedroom. One of the officers asked Elstad about the burglary without first reading him Miranda warnings. The officer didn't read warnings because he mistakenly believed that Elstad wasn't in custody at the time of the question. In response to the officer's question, Elstad admitted his involvement in the burglary. The officers then took Elstad to the police station, where they first read him Miranda warnings. Without the officers making any threats or promises, Elstad waived his Miranda rights and provided a more detailed confession, which the officers typed out and Elstad signed. Elstad moved to suppress both his initial confession and his subsequent confession under Miranda. The state trial court agreed that the first confession should be suppressed, but refused to suppress the second confession because Elstad had waived his Miranda rights before giving it. Elstad was convicted at a bench trial, and he appealed. The Oregon Court of Appeals reversed Elstad's conviction after concluding that both confessions should have been suppressed under Miranda. The Oregon Supreme Court denied the state's petition for review. The state of Oregon successfully petitioned the United States Supreme Court to review Elstad's case.